The whole controversy about trolls or non-practicing entities has evolved from a sense that patent owners who don't practice are equivalent to ambulance chasers. They're attempting to extract a quick settlement for less than the cost that an accused infringer would pay to defend themselves. It's gotten the attention of lawmakers who are now proposing a SHIELD Act that would assess attorney's fees against a patent owner who did try to use their patent in a way to extort a royalty, similar to the way a troll extracts a price from the travelers that cross their bridge. I think the SHIELD Act is going to have some effect in discouraging those ambulance chasing type suits, but it may create an entire process of having to scrutinize the infringer's lawyers' billing practices, and it may have some negative consequences as a result. Well, the SHIELD Act, one of its key aspects is to impose an assessment of attorney's fees against the loser in a lawsuit brought by a non-practicing entity that owns a patent. And the whole idea of assessing attorney's fees, first of all, that can already be done in cases that judges feel that's warranted, but it's going to be codified in the statute. I think it's going to create a mini lawsuit each time the amount of attorney's fees to be assessed is calculated. I would think that the defense lawyers would not be looking forward to exposing all the ins and outs of their billing practices, but that's what's going to happen if this SHIELD law comes into effect. You know, when you think about the controversy involving patent trolls, you really have to think back on some of the patents that people talk about that were actually owned by non-practicing entities, patent owners. One is Abraham Lincoln. Abraham Lincoln got a patent about 10 years before he was elected president for a way of buoying canal boats. The idea in those days was to load as much onto a canal boat as you could without bottoming out. There were standard depths and widths for canal boats, and he came up with a better way of having a canal boat stay afloat with more material loaded onto it. Lincoln worked the canals as a younger man and apparently had this innovation and got a patent for it. And if he had sued on it and say it was this day and age, he probably would have been labeled the original patent troll.